Welcome to the 144th session of Legal Empowerment through Interaction lecture series. We have been seeing new dimensions and new vistas and phenomenal performance in the sense like we were all enriched and empowered by the debate and discussions we had on section 112. Today we are moving a bit back in the section and in the chapter. We are dealing with chapter 6, exclusion of oral or parole evidence by documentary evidence. The journey continues. Let us have a wonderful session today, a fine Sunday morning. We welcome the speaker of the day, Justice D.V.S.S.Somayajulu, sir. Thank you for being with us today, sir. We also recognize the presence of Justice B. Ramkumar, sir, Justice Siddharamamurthy, sir, Justice Ramakrishnan, sir, Justice P.S. Narayana, sir, Justice P.B. Suresh, sir, and all of you. Wonderful participants, past faculty also who had addressed us earlier. All of you, let us make use of this Sunday morning to find out how far we can exclude oral evidence when we have some document in our hand. Over to you, sir. Somayajulu, sir.
Thank you so much, Shyam. Good to see so many of my illustrious seniors sitting here. Sir, pranams to everybody. And a good morning to all the participants who are here on this lovely Sunday morning.
Good morning.
Good morning, sir. This is a topic, according to me, a topic of seminal importance. Most of the practitioners of law are using what is contained in these sections without realizing the flow of the law or the source of the law. Most of us would have, I think, in our course of our careers, tried to set aside a document on the ground of fraud, tried to say that boundaries prevail over extents, or when you're judging cases, you would all have used these principles without an effect going to the source of the law. I'm grateful that such a lovely topic has been chosen. And I've been watching the steps being taken by this group. Step by step, the entire Indian Evidence Act is being analyzed. According to me, it is one of the greatest pieces of legal craftsmanship. I think we all have to pay a homage to Sir James Stephen. To imagine that at that point of time, such a lovely act was formulated is something I cannot imagine. I believe he is also the author of the Criminal Procedure Code and also the Contract Act. He has significant contribution, therefore, to the Indian judicial system and the Indian jurisprudence that we are using today. And what is so interesting about these sections is the interplay you see between the principles of interpretation of a contract, between the Indian Contract Act and also the Evidence Act. Under the Indian Contract Act, a contract which is void for uncertainty cannot be enforced. Here, an agreement which is void and the terms are so incapable of being understood, it cannot be. No evidence can be introduced. There is a wonderful interplay. When you interpret a contract, you say all the literal words should be first seen, then the entire contract should be seen. If these are still unclear, then you go to the surrounding circumstances to understand what the meaning of the author is or the idea of the author is. Therefore, according to me, there is a wonderful interplay between various enactments. And first and foremost, I would start by paying my respectful homage to this great author, Sir James Stephen. And as you see the manner in which the act is there, first you have oral evidence, chapter 4, then you have chapter 5, which deals with documentary evidence, and chapter 6, which deals with the exclusions. Therefore, first and foremost, I would like to start with that. And I also want to thank my good friend, Shyam Padman. It is a topic of such wide amplitude. So then I asked my good friend Shyam, for how long can I speak? He said, sir, you can speak for as long as you want, but after 30 minutes, I'll mute your mic. So I will try to confine myself and try to be as brief and analytical as possible. But as Justice Siddharamamurthy said, this is a topic where one person alone cannot justify the implications involved. As he rightly said, we will try and discuss this matter in this meeting or in another meeting. And I agree with him, sir, that this is a matter which requires greater investigation. First and foremost, and I would also like to bring it to your notice that there are quite a few youngsters who are law clerks in the AP High Court. Some of them have joined today. So sometimes if I go a little slow and try to read the illustrations, I hope the august audience would forgive me. In the last couple of days, some young law graduates have joined as law clerks, and some of them line in the
Kerala High Court is yet to get a law clerk.
It's just 2 days old, sir. 2-3 days old, they've reported, and a bunch of youngsters have just joined.
Wonderful.
Yes.
In case I slow down and read the illustrations, I hope you will not mind. First and foremost, of course, is sections 91 and 92. As we all know, these sections, oh, thankful. These sections exemplify or make it clear what is known as the best evidence rule. As you all know, the best evidence rule is a rule that seeks to preserve the integrity of the contract or the sanctity of a contract and wants everyone to first look at the written word as it appears. Section 62 and 64 of the Indian Evidence Act say that the primary evidence of a document is the document itself. This is also part and parcel of what is known as the best evidence rule. Now, the best evidence always is the primary evidence, namely the document itself. The document being the repository of the terms which have been agreed upon between the parties. The law makes it abundantly clear that if you want to prove the documents, the primary evidence is the document. Section 61 is on the screen. It says the contents of the documents may be proved either by the primary evidence or by the secondary evidence. Primary evidence means the document itself. And section 64 states that documents must be proved by the primary evidence, except in the cases hereinafter mentioned, which refers to section 65 and the manner and method in which secondary evidence should be introduced. Therefore, the best evidence rule, which is mentioned in 62 to 64, is again reiterated in 91 and 92. This is because when a document is written, the words are there for everybody to see. Human memory being what it is, sometimes people forget what they intended because of passage of time. Sometimes people deliberately forget what they meant and what were the meaning of the words that they used in order to get over the contract. Therefore, in order to avoid these two scenarios, either the frailty of human memory or the deliberate, amnesia that comes when a witness comes into the box and forgets the words in the document. To avoid and to ensure that these two are not lost, this act prescribes that the document itself should be the primary evidence and it should be exhibited. Now, if you can kindly see what section 91 talks about. Section 91 of the Act says, evidence of the terms of a contract, grants and other dispositions of property reduced to the form of a document. When the terms of a contract or a grant or of any other disposition of property have been reduced to the form of a document, and in all cases in which any matter is required by law to be reduced to the form of the document, no evidence shall be given of the proof of the terms of such a contract. This is the crucial word in my view. When the terms of a contract or a grant or other disposition have been reduced to writing, and in all cases where by law a document is required to be reduced to writing, no evidence can be given of the terms of the document except the document itself. So the emphasis in section 91 is on the terms of a document. Now, there are two types of documents which are dealt with in section 91, where there is a contract, a grant, or other disposition of property. By general interpretation, these words, using the principle of adjustum generis, etc., terms of a contract or of a grant or other disposition of property have been held to relate to documents which generally deal with disposition of property. Where they have been reduced to document, it is only the document that can be introduced to prove the terms of the document or secondary evidence. That's it. In other cases, where by law a document is required to be reduced to writing, the terms of such document can only be proved by producing the document. Now, there are documents which are required by law to be reduced into writing. I mean, it's all commonplace knowledge. A sale deed, an exchange deed, a gift deed, or a lease of a property for more than a year. A will, which is required to be attested by two people. These are all documents which are reduced to be writing by law itself. Now, to prove such documents, you will have to necessarily file and prove that document itself. But if a document is not covered by these, either by the first part of section 91, a contract, grant or disposition of property, or a document required by law, say a receipt of money, that can be proved by oral evidence. A receipt issued by oral evidence. Therefore, section 91 as it stands talks about evidence with regard to the terms of a document. There is a difference between the recitals of a document and the terms of a document. That is why I am stressing on the terms of a document. The terms of a document cannot be proved except by producing the document itself. In both the cases, whether it's a grant, disposition of property, or where the document is required by law to be reduced into writing. It is just the grant and disposition have been treated as generic terms. Now, the question often arises, one of the most interesting problems that we face is what happens if the document is inadmissible. A classic case is the case of a promissory note which is not at all stamped. A promissory note which is not at all stamped because of the operation of section 35 of the Stamp Act cannot be admitted into evidence. It is a document whose terms have been reduced into writing. The question that often arises in courts is what happens when there is such an other documents can be cured by paying the penalty and the deficit stamp. In case of a promissory note, the law on the subject as far as Andhra Pradesh is concerned has been very well settled by a full bench in AAR 1973, Andhra Pradesh 342, wherein the distinction between a promissory note, which is the sole repository of all the terms, and the distinction and a promissory note which is ancillary to the main transaction has been drawn. The full bench came to the conclusion that if the promissory note is the be all and end all of the entire transaction, it is the entire transaction. It cannot be received in evidence, the contract, it cannot be proved, therefore the case has to fail. But if it is a collateral executed for a collateral purpose as a security, or that there is a time gap between these two, the lending of the money, the receipt of the money, and the promise to pay, and the reduction of the and the said agreement onto paper, by the full bench drew this distinction. In fact, the full bench is 73 Andhra Pradesh 342 and AAR 85 AP 26. So those of you who are interested, is a wonderful decision of a learned single judge where he explained the distinction between these two. 85 Andhra Pradesh, page 26. The other important factor that I would like to draw to your attention at this stage itself is section 91 would apply if all the terms of the document are reduced into writing and they are contained in the document. Then the bar under 91 would be an absolute bar. But if all the terms in the document are not reduced or are incorporated into the document, you still have that little leeway or a little window within which you can still introduce oral evidence. Now, 91 has also three exceptions. Explanations, I'm sorry. The first part says, section 91, explanation 1. In fact, I would say the best way to understand the Indian Evidence Act and the sections is to read the explanations and the illustrations. Some outstandingly simple but clear illustrations are there which would make it very easy to understand what. When a first explanation, I'll first go to the explanations. This section applies to cases in which contracts, grants, or disposition are contained in one document or more than one document. So if the contract is contained in several letters or several documents which together prove the contract, you will have to file all of them together to show that these letters lead to the formation of the contract and these are the terms of the contract. The second explanation says when there are more originals than one original need to be proved. We often see, like in partitions, documents are executed in original. 3 or 4 originals are often there. When all the sharers take their own document and say, this is my document of title. Any one of these documents can be exhibited and proved as if it is the only original. The others need not be brought into evidence. This is what the explanation provides. Then explanation 3 is an interesting explanation. This clarifies that a statement in any document of a fact other than the fact referred to the document in this section shall not bar the receipt of evidence. Suppose there is a recital in another document pertaining to this transaction, evidence can still be given of that transaction. This is illustration E, if you can kindly see. You will find this. A gives a receipt for payment of money paid by B. Oral evidence can be given of the payment. It is not fully shut out. In addition to this, there are 2 exceptions which are also mentioned in this section. These deal with a public officer who is required by law to be appointed in writing. Public officer, let us say a judge is appointed and he takes charge of his post as a judge, exercises the functions of a judge or of a justice or the collector and district magistrate. It is not necessary to produce the primary evidence to prove that this gentleman was in fact appointed as a judge or as a public officer. A will admitted to probate can also be proved by the certificate of probate. As you all know, I don't know, in Andhra at least we still are not awarding probate, but under section 41 of the Indian Evidence Act, a probate granted by a court is conclusive proof of the will and the documents that are considered by the court. Therefore, when a will admitted to probate can be proved by producing the certificate granted by the court. These are the 2 exceptions which are mentioned in section 91. Because if you can see, there is a reason and a logic behind this. Public officer and official acts are presumed to be done in a proper manner. And a judicial act is something by a grant of a probate by a court is something that another court can take notice of. Therefore, these 2 are the exceptions. This is the rule of primary evidence. But what is even more interesting for the practitioner or for the judge is section 92. This is the section which carves out certain exceptions in the form of provisos to the rules contained in 91 and also 92. 91 and 92, in my view, are complementary to each other. And 92 is as follows. When the terms of a contract, grant or disposition of property, or any matter required by law to be reduced to the form of a document. This is almost exactly the words used in 91. Have been proved in accordance with the last section, where the terms of a contract and or any of a grant or other disposition or any matter required by law to be reduced to a form of a document have been proved, no evidence of any oral agreement or statement shall be admitted as between the parties to the instruments or their representatives for the purpose of contradicting, varying, adding, subtracting from its terms. I request all the youngsters particularly to pay attention to the words used. Where the terms of a contract have already been proved in terms of the previous section, no oral evidence can be introduced to vary, subtract, modify, or alter the terms of the contract and by the parties or their representatives in interest. The reason why I'm drawing your attention at this stage, when we go to 99, we'll find another exception to this. So this section, as it applies, talks of terms of a contract which have been proved. The document has been received in a court of law or in the course of a trial. Thereafter, neither the party to the document nor the representative in interest can introduce oral evidence to vary, modify, alter these documents. Therefore, it only talks of the terms of a document again. So the question that often arises is, if the entire document is void in law, what happens? Can oral evidence be introduced or not? If the entire document is vitiated by fraud, misrepresentation, does 92 come in the way or does 92 allow you to give evidence? So this, if you look at the plain grammatical meaning, it only talks of the terms of any such contract being proved in a court of law, cannot be varied, modified, altered by parole evidence. But if the entire document is void for want of consideration, for fraud, due to misrepresentation, inducement, etc., 92 will not come in the way. And for this, you will have to look at section 92, Proviso 1. You look at it carefully, you look at 92, Proviso 1. It talks of any fact may be proved which would invalidate any document and would entitle a person to a decree, order relating thereto, such as fraud, intimidation, illegality, want of execution, want of capacity, want of failure or consideration, mistake of fact or law. The distinction between the main section and the exception carved out by the proviso is this. The main section talks of terms of a document. Proviso 1 talks of a factor which would invalidate the entire document. If the document in its entirety can be invalidated on the ground of fraud, want of consideration, mistake of fact, law, etc., 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 this is the proviso which gives you the support to introduce evidence. The distinction is between the terms used in the word term used in section 92 and a proviso which says a fact which would invalidate any document. By using the words any document, you can draw the conclusion that it is not merely confined to a document which has been mentioned in these, namely a grant, a disposition of property, or any other document required by law to be reduced into writing. Any document can be set aside by introducing oral evidence, provided you can prove it is induced by fraud, misrepresentation, etc., etc., etc. So Proviso 1 is the first exception to the law contained in 1991, section 91 and 92. This enables you to introduce evidence to set aside the entire document. Again, the terms of a document are still held to be sacrosanct, except in certain stages you cannot introduce evidence. Coming to section 92, Proviso 2, it says the existence of any separate oral agreement as to a matter on which the document is silent and which is not inconsistent with its terms may be proved. In considering whether or not the proviso applies, the court shall have regard to the degree of formality of the document. Here you will notice a very, very clear and discernible change. The existence of a separate oral agreement as to a matter on which the document is silent and it is not inconsistent with its term can be given. Suppose an important understanding, whether by oversight or otherwise, has not been included in the document. Such a issue can be proved by parole or oral evidence, provided it is not inconsistent with the terms of the document. The overall bar under 91 still applies. You can't have terms contrary to a written document. If it is not inconsistent, still you can prove it. But here, the court is given the option of either accepting the evidence or rejecting it right away, because the last part of the clause reads, in considering whether or not the proviso applies, the court shall have regard to the degree of formality of a document. Suppose a document is properly registered with witnesses. It will be very tough for the person to say, despite a document which is typed and signed instantly in the presence of two witnesses, it is understandable, but something is forgotten. But when you go to a registrar's office, go take your witnesses, go there and register the document, a degree of formality is attached to that document. Therefore, here the court is given the leeway to accept it or not accept it, basing on the fact that the document is now a very formal document, reduced into writing and registered. This is something which you should be very, very careful. Please see illustrations F and G. You will understand what I'm trying to say. Illustration F talks of A orders goods from B by a letter in which nothing is said as to the time of payment and accepts the goods on delivery. B immediately sues A for the price. Then A may show that the goods were supplied on credit for a term that has not yet expired. I'll read it once again. A orders goods from B. There is a letter evidencing the transaction, but that letter is silent as to the time of payment. I promise, he sent the goods, this gentleman received the goods, the letter is silent as to the terms of payment. B immediately sues A for the price. Then A can show that the goods were supplied on credit for a term that has not yet expired. So therefore, going by this example, A can say that the suit is premature. It is filed early before the term of credit has expired. Now, similarly, see illustration G. A sells B a horse and verbally warrants that the horse is of a sound quality. A gives a paper with these words, brought a horse for rupees 500 from A. B may prove the verbal warranty. The letter by which the transaction is evidenced does not contain a warranty of the soundness or the health of the horse. Therefore, the law permits the introduction of evidence to prove that the horse was meant to be healthy and let us say he failed or whatever. Therefore, these are two simple examples of a clause which is missing in the letter, of a clause which is not inconsistent with the terms of the letter, and therefore oral evidence is permissible. Therefore, under the first proviso, you can introduce oral evidence which would invalidate the entire document. In the second proviso, you can introduce evidence subject to the decision of the court, depending on the formality of the document, of evidence, when the document is silent and the term you are seeking to introduce is not inconsistent. Then proviso number 3. I hope you'll also keep in mind the distinction, the term of the document and invalidating the entire document. Proviso 3 talks of the existence of a separate oral agreement which constitutes a condition precedent for attaching any obligation can be proved. If there is a condition precedent prescribed in the agreement between the parties, but that condition precedent has not been reduced into writing, a party can still prove, I need not perform my obligations under this document unless the condition precedent is proved. Very, very often we find this in our agreements of sale and specific performance suits. Sometimes person undertakes to get the land surveyed to establish the exact extent, exact boundaries. Let us say by mistake that is not mentioned in the agreement of sale. The vendor can still, it can still be proved that there is an agreement for survey of the land, there is an agreement for establishing the boundaries of the land, and thereafter the other conditions, obligations would follow. A very interesting case which I would like to bring to your notice in this is AIR 1967 Supreme Court, page 333. AIR 1967 Supreme Court, page 333. Narayan Das Gaziwala versus Pappamal. Now, this is an interesting case where this is a case between a principal and an agent. There was a promissory note executed for payment of the commission. But along with the promissory note, there was a collateral agreement not to enforce it for a certain period of time. So along with the promissory note which establishes the agreement, there was a collateral oral agreement not to enforce it between the principal and the agent. And this is what the Supreme Court said. The finding of the High Court is that there is a collateral oral agreement that the obligation under the promissory note will not be enforced for 5 years unless the amount was due after accounting for the period of the agency. In our opinion, the agreement was not related to the discharge of obligation, etc., but it was a condition precedent for enforcement of the promissory note, and it is open to the plaintiff to adduce evidence of an oral agreement under the third proviso to section 92 of the Indian Evidence Act, 1956.
Citation.
I'm sorry, sir.
Citation, please.
1967 Supreme Court 333, sir.
Thank you.
No, not at all, sir. As far as the those of you who are dealing cases in arbitration and engineering contracts, under 91 and 92, one of the best judgments I found was 96-4 Supreme Court cases 551. 1996-4 Supreme Court cases, page 551. This was a case where there is an agreement to pay certain amount to the contractor, but the engineers for certain reasons passed the bill for a higher amount. X was agreed to be paid under the contract. The engineers for their own reasons passed it for X plus 10 or a Y amount. This is Ramaswamy held. Bar under 91 and 92 is absolute, and merely because the bill is passed for a higher amount, the terms of a written contract cannot be ignored or overlooked, and they are bound to be followed. This often, that's why I prefaced it with those in arbitration and engineering contracts. It often happens, bills are passed. You know the reasons, I can't say it in an open forum like that. Bills are passed for higher amounts. When bills are passed, you can fall back on 91 and 92 and say, there is a written term, the written term should be enforced. And therefore, we are now dealing, I don't know, the youngsters, yes, I think some of them are online. Therefore, the provisos, these contracts which carve out the exceptions, are dealing with a lot of practical things that we all use in our regular practice. In this 67 Supreme Court, the agency, the entire payment was postponed because the condition precedent has not been fulfilled. Now, Proviso 4 talks of a distinct subsequent agreement. If you notice the difference between 3 and 4, 3 talks of the existence of an agreement which is a condition precedent. Proviso 4 talks of a distinct subsequent oral agreement which has been reduced into writing. Now, I think the proper way to read it would be to reverse the, in fact, I tried my best to read it. I had a little confusion. I saw a textbook by Professor L. Nageshwara Rao on law of evidence, a beautifully written book. In that book, I found a nice explanation of the way this proviso should be read. He said, you overturn it, let the last sentence come up, and then you will. This is the way you should read Proviso 4. Except in cases in which a contract, grant, or disposition of property is by law required to be in writing or has been registered according to the law in force for the time being as to the registration of a document, the existence of a distinct subsequent oral agreement to rescind or modify any such contract may be proved. Therefore, except in cases where a document has been reduced to writing or has been registered, these 2 cases are taken out. In all other cases, you can prove a distinct subsequent agreement to disprove the terms and conditions of the agreement. First is that the document is not required by law to be in writing, but it is reduced to writing by way of abundant caution, let us say, by the parties. The second is a case where, although the document is not required to be registered, they reduce it into writing and get it registered. These are the 2 ways we can look into it. If the document is reduced to writing and they choose to get it registered, a subsequent oral agreement cannot be pressed into service to distinguish the terms. I mean, the old timers will understand the good old partition lists. The partition list was not required to be registered. Sometimes after the partition, sometime later by way of abundant caution, it used to be registered. Once it is registered, this sort of an issue would crop up. So therefore, where a contract grant or disposition of property has been registered according to the law in force, the existence of a distinct subsequent agreement to rescind or modify the earlier document which is reduced into writing and registered. Again, we go back and to go to 91 and 92. The proviso merely reiterates what is stated earlier. Partition lists are the first example that come to my mind. 2000 volumes, 2006 volume 5 SCC. 353 is a case that comes to my recollection. Kindly read it. It will help you to. Shaktivel versus Venugopal Pillai. Anyway, this is also useful. Now we have dealt with 4 provisos. Let us go to proviso number 5, which is again a very interesting proviso, which arises for those who are essentially dealing in commercial contracts and supply of goods, etc. Any usage or custom by which incidents not expressly mentioned in any contract are usually annexed to contracts of that description can be proved. Again, provided that annexing of such an incident should not be repugnant to and inconsistent with. Now, usages of trade are something that are very peculiar to the merchants. They have their own usages of trade. In fact, one very interesting case that will help all of you understand what I'm trying to say, AAR 1961, Supreme Court, page 1285. AIR 1961 Supreme Court, page 1285. This was a case pertaining to a trade between India and East Africa. It said this contract is subject to the usual force majeure clause. This contract is subject to the usual force majeure clause. Nothing else was said. So there was a litigation. This usual force majeure clause was argued as saying it is so wide for uncertainty, it is not clear, it cannot be enforced. Usual force majeure clause. If you read the entire judgment, you would see the learned counsels there made an effort to bring out various types of force majeure clauses and said, which of these is the usual force majeure clause? They brought clauses from all over the world. But the Supreme Court upheld the clause. The Supreme Court upheld the clause and said, this is a trade between India and East Africa which has been carried on for generations together, for centuries together. So therefore, the usage of the word usual force majeure clause is something that can be ascertained and it is not void for uncertainty. If you examine any merchant from Africa or India, he will tell you what the usual force majeure clause is. Therefore, this is a case which is very well applicable to proviso number 5. Any usage or custom by which certain incidents are not expressly mentioned in the contract and are usually annexed to the contract of that description. The Honorable Supreme Court took support from contracts of that particular description with the usage of trade and are not mentioned in the document. Yeah, a force majeure clause which says usual force majeure clause. What is a force majeure? Storm of force majeure, a cyclone of force majeure, strike of force majeure. And this matter went all the way to the Supreme Court, and the Honorable Supreme Court held that this is a case that, yes, Dhanaranjamal Govindram, yes, Mr. K.V. Rao has already put it up on the chat box. So this is a very interesting case which makes interesting reading of the manner in which the learned counsels tried to fight, the manner in which the Honorable Supreme Court came to the conclusion. So these are, similar issues are also there in the other part where we go a little later. Usages of trade, custom usage, how they can be proved are also considered. Now, number 6 is again, any fact may be proved which shows the manner in which the language of the document is related to the existing facts. I mean, I can give a very simple example. If the agreement relates to a cat under this provision, you can't introduce evidence of a dog. But if the agreement relates to a dog, you can prove whether it's a Cocker Spaniel or a Alsatian dog. If any fact may be proved which shows in what manner the language of a document is related to the existing facts. Oral clarification can be permitted only when there is a little bit of ambiguity in the document, but it is otherwise certain. If the sale is of a dog, you can prove which breed of the dog was meant. Of these, in my view, what the earlier provisos, the first 2-3 provisos are what are most important, particularly for the practicing advocate. Most of us in our careers have used these provisos to this section without really being aware of what was there, to invalidate documents, to fight that documents are not what they actually are, etc. The exceptions to 91 and 92 are in the subsequent sections, 93 to 99. Now, most of you, I think, are aware of what are patent. What are ambiguities first? Ambiguities are of two types. Ambiguity is something that that introduces an element of uncertainty into a document. Now, these are two types of ambiguities. One is the patent, ex facie visible, openly visible ambiguity. And there are certain ambiguities which are latent, which are not easily visible unless you go into the depth of the document. Patent, ex facie visible to the eye documents are the patent ambiguities which are dealt with by 93 and 94 of the Evidence Act. Latent ambiguities or ambiguities which require some amount of examination, some amount of determination, which are not visible on an ex facie reading, are in 95 to 97. Now, may I request all of you to kindly look into 93 first. It sets again the best evidence rule. Section 93 deals with what is an incurable defect, something that cannot be explained or mentioned. Where the language used in a document is on the face of it ambiguous or defective, evidence may not be given of the facts which would show its meaning or supply its defects. If the language used in the document is on the face of it. Now, the illustrations are very, very simple and easy to understand. A agrees in writing to sell a horse to B for 1,000 or 1,500 rupees. Evidence cannot be given as to which price was to be paid. Similarly, the next example, a deed contains blanks. Evidence cannot be given of facts which show that they are meant to be filled. These again go back to 91 and 92. When the document is ex facie and ambiguous, it does not convey any meaning. It is patently defective. Like in that first exam illustration, I agree to sell my horse to you for 1,000 rupees or 1,500 rupees. Again, we go back to the Indian Contract Act. That is why I said there's a wonderful interplay here. An agreement void for is void for uncertainty. Here also the price in illustration A, whether it is 1,000 rupees or 1,500 rupees, no court can enforce it since it is not certain. A wonderful case on this, for those of you who are interested to pursue this line, is AAR 1958 Supreme Court, page 512. 58 Supreme Court, page 512. This was a case arising from Bombay. This is a case relating to supply of material. There was a huge strike. Because of that huge strike, the factories had to be shut down and the supplies could not be carried out. Then the parties went into a discussion and time for delivery was agreed to be extended. And I'll just read the letter. At present, it is difficult to say how long the state of affairs will continue. And as such, we regret that we cannot fulfill the orders placed by you with us in time. Under the circumstances, please note that the delivery time of all your pending contracts with us shall automatically be understood as extended for the period the working is stopped and till the normal state of affairs recurs. This is what the letter says. I'll read it once again. The period shall be automatically understood to have been extended for the period of till the working is stopped and till the normal state of affairs recurs. This part of the letter fell for consideration before the Supreme Court. So till the Supreme Court held, the time is extended for the period till the working is stopped, is capable of interpretation, of being narrowed down. You know the date on which the working is resumed. But the second half of this letter, till the normal state of affairs recurs, the Honorable Supreme Court held that this term is incapable of being ascertained. It is ambiguous. Oral evidence cannot be introduced to show what is the normal state of affairs and when it will be restored. The beautiful judgment, not a very lengthy judgment, I request all of you to. So the first part of the sentence stating that till the strike is called off, the Supreme Court said, yes, these are definite, determinable dates. But till the normalcy restores, what is normalcy? When all the workmen come back, is it normalcy? When the raw material comes, is it normalcy? When the road transport is restored, is it normalcy? Or when power is restored? All these matters were discussed and the Supreme Court said, this is not a contract for which oral evidence can be introduced to explain what is wrong. Therefore, if you read the example, the section 93, when the language used in a document is on the face of it ambiguous, evidence cannot be given of the facts which would show its meaning or supply its defects. This is a wonderful judgment on the subject. Now, the next section that comes for our consideration is 94. This is again a reiteration of what we've already been discussing. When the language used in a document is plain in itself, and when it applies accurately to the facts, evidence may not be given to show that it was not meant to apply to such facts. This is what we have discussed earlier. Once the document is clear, once the document is understandable, you do not have the right to introduce oral evidence to explain what it was meant to apply to. Again, the illustration is very, very clear. A sells to B my estate at Rampur containing 100 bighas. A has an estate at Rampur containing 100 bighas. Evidence cannot be given of the fact that the estate meant to be sold was once situated at a different place or a different size. Rule of law that we have been discussing right from the beginning. Once the terms of a contract have been reduced to writing, they are clear, there is no ambiguity, you cannot have oral evidence to explain those, and it has to be shut out immediately, particularly when the language is clear. This is the importance that the written word that is attached to a written word, the solemnity of an agreement. Therefore, 93 and 94 deal with what is patently visible. But what is not patently visible are the latent defects, or the defects which are inherent in a document, which are only visible after some examination and some amount of confusion arises. Now, kindly look at section 95. This is a section I think most of us would have used in our careers without falling on the literal word. When the language used in a document is plain in itself, when the language used in a document is plain in itself, that means the language is clear, but there is a doubt of it in reference to the existing facts. Evidence can be given to show that it was used in a peculiar sense. Let's read it once again. When the language used in a document is plain in itself, but when it is applied to the existing facts, it does not convey the proper meaning. Then you can give evidence of what was meant or that it was used in a very peculiar sense. Now, the classic example which most of us used are the discrepancy between boundaries and extent. All of us have used this proposition of law and said, when there is a discrepancy between the boundaries and the extent, the boundaries prevail. Talk of a... Yes, sir.
Ordinarily.
Ordinarily. Yes, ordinarily. Talk of a sale deed, sir, which has clear and crystal boundaries. On a plain reading of the document, you find that the boundaries are clear. They don't need any further explanation. But there is a discrepancy in the survey number or in the extent. Something, a mistake had occurred genuinely. Then you can, although the language is clear, I convey to you my land in survey number 1, measuring 1 acre, comprising of north, east, west, south, the 4 boundaries. But what was meant to be conveyed was slightly different. Then time and again, all the high courts in the country, including the Supreme Court, have held that it is the boundaries that prevail. And that proposition of law has emerged from a discussion of this particular section. I think everybody is aware of it. There is no need for case law on this, including the Supreme Court of India. If anybody is interested, 2006, 5 Supreme Court cases, 466. Andhra Pradesh has a number of judgments, of course. It's settled. But I have another doubt which has arisen in my mind. If there is a difficulty between the body of this, we are talking of the schedule, a discrepancy in the schedule, survey number, extent with the boundaries. But if there is a difficulty or a discrepancy between the body of the document and the schedule, what would prevail?
Body.
I'm grateful, sir. I don't know how many.
Unlike in the case of a will. Unlike in the case of a will.
Yes,
will, it is always the subsequent clause.
The earlier clause that's for the contractual letter. But the interpretation of the Supreme Court is 2004, 4 Supreme Court cases, 266. Four Supreme Court cases, page 26. Narayanan versus Kumaran. This was a case, sir, where there was a bequest being made and stealthily something was introduced in the schedule. In the original body, what was to be bequeathed was actually described, but in the schedule something else came. Therefore, the Supreme Court reconciled it by saying that when the schedule describes it with such clarity, it is the schedule, when the body describes it with such clarity, it is the body of the document alone that should prevail and not the schedule. Without going into Ramkumar Saab, without that proposition of the earlier clause prevails over the later clause in a regular contract, unlike a will. But the conclusion that the Honorable Supreme Court came is that ultimately it's the body of the document which contains and expresses the mind of the donor in this case, or the vendor. It shows what was meant to be conveyed was mentioned in the body. Therefore, they said the schedule of the document should not be allowed to override the recital clause. You please see I think I request all of you also to kindly see the illustration, which again conveys the meaning very, very clearly. A sells to B his house, which is in Calcutta, my house in Calcutta. A had actually no house in Calcutta, but it appears he had a house at Howrah in which B has been in possession since the execution of the deed. Therefore, these facts can be proved to show that the deed related to the house at Howrah. The language used in the document is plain in itself. It relates to a house, a sale of a house. But when it is applied to the existing facts, there is an ambiguity. Therefore, that ambiguity can be cured by introducing oral evidence. If we come to section 96, this deals with what is known as the rule of equivocation, or the rule that it applies equally to more than one. I would request all to read the illustration first to understand what the section actually means. Illustration B, I think, is very easy to understand. A agrees to accompany B to Hyderabad. Full stop. Evidence may be given of the facts showing whether it is Hyderabad in Deccan, Andhra, in Telangana, or Hyderabad in Sindh, Pakistan. Therefore, where it can equally apply to one or more things, and there is this latent ambiguity. Where is this Hyderabad? The document merely says A agrees to accompany B to Hyderabad. There are two Hyderabaads, one Hyderabad in India. I mean, when this Evidence Act was written, I don't think the distinction is there. I'm trying to add words to the illustration. I don't know if it is permissible or impermissible, but I feel there is an ambiguity today. A agrees to accompany B to Hyderabad, full stop. Evidence may be given to show whether it is Hyderabad in Deccan or Hyderabad in Sindh, Pakistan. Similarly, illustration A. A agrees to sell to B for 1,000 rupees my white horse. A has two white horses. Evidence may be given to show which of these two white horses is meant to be sold. For all the youngsters, for all the seniors, I think it might be boring. For the youngsters who are there, the illustrations in the Evidence Act, according to me, and in the Indian contract are extraordinary. And the best way to understand what the section means more often than not is to read the illustration. The entire section, if you read it, will look confusing, but if you read the illustration, it becomes so simple. So where the facts are such that the language used can be used to apply to one and could not have meant the other, or several people and things, evidence may be given of the facts which show that those persons or things it was intended to apply. Therefore, if there are two or more people, things, or set of facts which are mentioned there, you can always introduce evidence to prove this, Hyderabad in Deccan or Hyderabad in Sindh, because there is a latent ambiguity. On the face of it, the language appears plain. I agree to accompany you to Hyderabad. There is no doubt in that language. There is no ambiguity in that language. But the question is which Hyderabad? So this is a latent ambiguity that arises after you examine the document. Similarly, I agree to sell my white horse to you for 10,000 rupees. Sale is clear, 10,000 rupees is clear. White horse. He has two white horses. Which of the two? This is a latent ambiguity which is visible after you examine the document. You can give evidence even though the words are plain. Because the earlier sections were, if the words of a document are plain, they should be given meaning. But if the words are plain and still there is a little ambiguity, you can cure it, clarify it by the evidence under this section.
Sir, how do you reconcile it with section 29? And that is uncertainty. I mean, two white horses, which among section 29?
No. Section
29 of Evidence Act.
The entire agreement.
Contract.
The entire agreement is void for uncertainty. Here,
uncertainty.
It is a case of explanation of the document which is otherwise clear.
Subject matter is there. Only thing is you have to identify.
Because I intended to sell a horse for a particular amount. That is there. Which horse is a question.
The buyer and the seller are clear.
Suppose I don't have a white horse at all, then the question will be different.
Exactly. That's that. Using the same example, Ramakrishnan sir is absolutely right. He doesn't have a white horse at all. That is uncertain. Absolutely uncertain. Like that letter that I read. Time is extended till normalcy is restored. When is normalcy?
Supposing he has a black horse.
Or a black sheep. So that's the, now 97 is again a continuation of the same principle. When the language used partly applies to one set of facts and partly, but the whole of it does not apply correctly, evidence may be given. Again, the illustration is again dealing with mistaken descriptions. Please read the illustration, which I think would make the section amply clear. A agrees to sell my land at place X in the occupation of Y to B. A agrees to sell to B his land at place X in the occupation of Y. A has land at X, but it is not occupied by Y. First, he has land at Y. He has land in occupation of Y, but it is not at the place X. I'll read it again. A agrees to sell to B land at place X in the occupation of Mr. Y. A has land at X, but that land is not occupied by Y. But in fact, he has land occupied by Y, but it not at place X. In such circumstances where there is this ambiguity that the sale is otherwise confirmed, A agrees to sell to B. The land is described with some amount of imperfection. You can also give oral evidence, something like our boundaries and survey numbers. And then what is again more interesting is section 98 in my view, again for the commercial lawyers. Evidence can be given to show the meaning of illegible or not commonly intelligible characters, foreign, obsolete, technical, local, and provincial expressions, abbreviations of words used in a peculiar sense. This is another very interesting section. Suppose the word IT is used. It can mean income tax, it can mean information technology. Suppose the word bow is used. For an archer, a bow is different. For a maritime lawyer, the bow is the bow of a ship. A baker's dozen is not actually 12, it is 13. If they say New Year, for Rajasthanis and Marwadis, New Year is with Diwali when they start their annual accounts. So these are all customs, usages, peculiarities which are allowed to be explained. You please see this. Evidence may be given to show the meaning of illegible or not commonly intelligible characters that are not very commonly used, of foreign words, obsolete, technical, local, and provincial expressions, abbreviations, end of words used in a peculiar sense. The Indian Evidence Act also allows us to introduce evidence of an expert. Section 49 deals with it. We summon an expert to explain a term, to explain a scientific term, to explain the usage of a particular term. Or the earlier judgment that I had cited, force majeure clause of the usual clause. If it is used in a peculiar sense, you can still give evidence of these matters, even though the document is otherwise clear. There is certain unintelligible character which is not understood, a foreign word, like all the Latin phrases that we have begun to use. Somebody or the other had to explain them first and bring them into our usage. We started following them. Technical words, local and provincial expressions of abbreviations. I think those who speak Telugu would understand. Gunta, in our part of the world, talks of a young girl. In Hyderabad area, Gunta means a depression in a road.
Gun.
See, the word Gunta, if it is used, can mean two things in two different areas. That is the reason why words that are not commonly used, foreign words, technical words, etc., can be given. New Year is one classic example. In fact, I think Kerala also had some similar system of a New Year, which is different from the regular Gregorian calendar. Different. Very old judgment, but hardly had any facts, so I gave it up. There they said the judgment of the lower court is right, one paragraph. Therefore, you read the illustration. There is a case also, this is from, but I couldn't find it. Anyway, but what I would like to say is that, as I said earlier, the word bow. For an archer, it means something. For a ship architect, it means something. For a merchant, shipping lawyer, it means something. Words like aft, starboard, astern, they won't say ahead and back. Full astern, full ahead, full astern. Astern is go back. In fact, I had a very interesting case, sir, in Visakhapatnam, where a ship comes in. Most of you know it is controlled by a tug. A tug brings the ship into the port. But the ship crashed against the jetty of the port. So we sued the ship owners for damages caused to our property. And the man who had to give evidence was the master of the vessel. And once he came and gave evidence, all his entire evidence was shipping terms. I ordered them to go full astern, full aft, but this fellow didn't. And the judge, after recording the evidence, he asked the typist to correct. After she typed it, he gave it to the master and he said, correct it. This man drew lines top to bottom and said, sir, the entire deposition is wrongly typed. Then we had to bring in expert evidence, take permission, explain all these terms, then introduce evidence. So these sort of difficulties arise, and that's why even if such a term is used in a document, the Evidence Act gives you the liberty, even though the terms are clear, if it can mean more than one thing. That is why the Evidence Act gives you the liberty to introduce oral evidence to explain the meaning of an otherwise clear document. Sir, section 99 is the last of the sections. Now, if you remember what I said earlier, 92 and 99, the distinction is this. Section 92 of the Evidence Act talks of the parties to a document and their representatives in interest. 99 gives the liberty to a stranger also to come in and to give evidence. That is the distinction between 92 and 94. 92 talks of no evidence of any oral agreement or statement shall be admitted as between parties to any such instrument or their representatives in interest. It is only these people who are prohibited from introducing evidence, the parties to the document or their representatives in evidence. But when we come to 99, it talks of a stranger to a document also introducing evidence. Persons who are not parties to a document or their representatives in interest may give evidence of any facts tending to show a contemporaneous agreement varying the terms of a document. This is the distinction between 92 and 94. Even the proviso to Proviso 4 to section 92 deals with a contemporaneous agreement to modify an earlier agreement also comes into play. This is the only distinction. 92 says persons who are not parties to a document or their representatives in interest can give evidence varying the terms of a document. This is in substance what I wanted to speak about, but what you should see the march of the section. First it talks of clear document, then it talks of ambiguous document, how to introduce evidence. This is I think the beauty of the Indian Evidence Act. This is the sum and substance of what I wanted to say. My knowledge is limited to this. I do not want to enter into dangerous waters. Say something. Any other questions or?
We'll go straight to Justice Sridhar Ramamurthy, sir.
Ammo. He's a dangerous working guy.
Not only excellent, but captivating.
Thank you, sir.
Exactly.
Sir, for youngsters, I would like to repeat what you said. Illustrations are self-explanatory of the provisions of law.
Yes, sir.
So therefore, there is no scope while interpreting provisions of the Indian Evidence Act to interpret contrary to the legislative intent. In the present day enactments, you see in contrast, we don't find even a single illustration. That is why many of the enactments are failing, or we are getting inconsistent interpretations and inconsistent decisions. Example is electronic evidence. See, coming to the Proviso 1 to section 92, sir, for youngsters' sake, I would like to mention that it has two parts in my considered view. It applies in two different situations, as we have also pointed out. First part is proof of facts which would invalidate a document.
Yes.
That means the invalidity affects the document ab initio. Like, though section 100 says that this part will not apply to Indian Succession Act, for illustration sake, I may mention that a will is executed, but the property does not belong to the testator.
Yes.
The second part deals with proof of facts which would entitle any person to any decree or order relating thereto. Then what are the kinds of facts which can be referred to in the second part? As you were also mentioning, I will also add to what you have mentioned, sir. One is fraud. The other is intimidation or coercion, illegality, want of execution, like it is not attested though compulsorily attestable, want of capacity, want or failure of consideration, mistake of fact, mistake of law. These are the various facts which can be proved and which entitle a person to a decree or order relating thereto. This is the first proviso, sir. Then regarding the other aspect, in my humble view, section 91 applies to both unilateral and bilateral documents, whereas section 92 applies only to bilateral documents. And I would like to know your view on this. Is it so?
Yes, sir. I think that is correct.
Yes.
91, 92, that is the... Yes, sir.
So while 91 applies equally to bilateral documents like contracts and unilateral ones like wills, etc. But 92 applies only to bilateral documents. This is my view, sir. Then one more aspect I would like to talk about is Proviso 3, sir, of section 92. I will read it for convenience of the youngsters once again. The existence of any separate oral agreement constituting a condition precedent to the attaching of any obligation under any such contract, grant, or disposition of property may be proved. Under the Transfer of Property Act, condition can be condition precedent or condition subsequent.
Yes, sir.
Whether this proviso only speaks of condition precedent, whether this proviso can be applied to a situation where it is a condition subsequent is a doubt which lingers. I can cite an example. Suppose A agrees to give his property to B if B marries A's daughter. It is a condition precedent.
Yes, sir.
Dowry Prohibition Act.
Yes, sir. Take a second case, slightly modifying the illustration. If A right away gives his property to B and says that B will be divested of the property if B does not marry A's daughter, it is a condition subsequent. So because the wording employed is condition precedent, whether this proviso can be applied to condition subsequent.
Existing fact.
Because generally the provision says subsequent oral agreement. So the proviso is being applied, it appears, when it comes to case law, to subsequent condition subsequent also.
We come across gift deeds, sir. Gift deeds. Gift is executed due to natural love and affection. But after the gift,
on condition that you will look after me. You will look after me.
No more love and affection. And he executes a rectification deed or cancellation deed.
See, as your Justice Ramkumarji, as you are rightly pointing out, even it is a condition precedent, the general law is if the original contract has a condition precedent and it has already been acted upon by both parties and it is part performed, the condition cannot be invoked at a later stage is the general law.
Yes,
exactly.
So therefore, the proviso cannot be made use of.
Correct.
These are the aspects I wanted to clear for.
I think that recently the Kerala High Court has held in that case where a document whether the document can be set aside or not by a senior citizen. Suppose there is an agreement, there is an intention on the part of the gift, the donor was to look after me during my lifetime. And that was not done, but that was not specifically mentioned in the document. The question arose whether using the act, whether such a document can be set aside. There were conflicting decisions. Subsequently, it was referred to a full bench. Full bench said that unless it is specifically mentioned, you cannot enforce it because you cannot set aside the document. That is what the.
But is it not a document of transfer inter vivos gift? Once the transfer is effected, can there be a conditional? Can there be a conditional gift?
No,
can there be a conditional gift?
There is a specific provision in the
Senior Citizens Act which says
section 26 or 27 of that act, which says that otherwise.
The full bench only said that for invoking that provision, it should be
specifically mentioned in the document.
That's all. You cannot. The earlier decision said that Kerala High Court said that because it can be inferred that it is all for taking care of me.
It is impliedly that on the assumption that he will look after, I will execute it. That assumption cannot be taken.
Even otherwise, section also says so. I think somewhere in section 20, I don't remember the exact section.
24 or something.
But I feel that the intention of the legislature was that if some purpose is there for the purpose of execution, if it is not fulfilled.
Absolutely true, because it is to be treated as a gift, because it's a condition. And Somayajulu,
because onerous gift is also not prohibited.
Absolutely true.
Is the wording, as you rightly pointed out, is only subsequent. That's correct in that proviso.
And one more aspect, sir.
Yes.
Coming to section 98 for youngsters only, newcomers.
We are also youngsters, sir.
I am benefited, getting slowly re-civilized.
There are two aspects.
No, because the way in which we have not understood this section are being enlightened now.
Yeah, no.
Somayajulu, sir.
Oh, no.
Two parts, sir. Meaning of illegible and not commonly intelligible characters. For the youngster's sake, I am repeatedly saying, while illegible handwriting can be cleared by the author or a person who is familiar with the handwriting. That is the first part. So evidence can be given. The second part is unintelligible characters. Supposing a shorthand writer has taken, the shorthand dictation. He is not available. He is not available. Yes. Another shorthand writer can transcribe it. His evidence can be taken. So foreign, absolute, technical, local and provincial expressions can be explained by experts, as rightly pointed out by Justice Somayajulu Garu, by making use of section 49.
Will a doctor's prescription fall under that?
99% of the time, sir.
Thank you, sir, for the opportunity.
No, even some of the judges' handwriting may not be even possible for the judge himself to read later.
Why just the handwriting, even the judgments?
Thank you for the opportunity for allowing me to share my humble thoughts.
Thank you, sir.
Once again, excellent, Somayajulu Garu.
Thank you, sir. Me dayavalli ikkada unnanu because of you.
Justice Ramkumar, sir.
Excellent articulation, Mr. Somayajulu.
Thank
In
you,
fact,
sir.
I have two doubts. It may be foolish also because I am slowly, gradually getting civilized, re-civilized. The Proviso 1 to section 92, will not a sham and nominal document fall under that?
Yes, sir, I think it is.
Sham and nominal.
Yes.
Want of consideration. No title passes. Sham and no consideration. No consideration.
Ramkumar sir, the usual example given is Kozhikode and mortgage. Though it is as a mortgage or as a lease, it is not
really
raising a loan. Even though we
Calicut mortgage. There's a decision by Justice Kochudaman.
Yes,
what is that mortgage?
Sir, for taking a loan, I'll execute a sale deed in your favor. Though it was never intended to be used as a sale deed, everything remains with me, but in the document will be there only as a security for you to transfer.
In fact, it happens. Yes, they take a sale deed.
Sham document never intended to be acted upon or acted upon.
Yeah, that's because of the dearth of accommodation in Calicut, they used to execute
mortgage deed for lease deed instead of lease deed.
And get an advance also.
In case of sham document, I think bar under section 92 cannot apply. Because I think we have a
proviso.
You can invalidate the document.
Because a sham document
that is first part.
Use parole evidence against the document.
But sir, kindly see, there is a decision by the Privy Council long during, I think it was 36 Privy Council.
Yes.
Some Tyagaraj Mudaliar or something, 36 Privy Council. And that is followed in Gangabai. That's a AR 1982 Supreme Court, page 20. Wherein it is clearly held that the bar under section 92, it can never get attracted where a transaction which is recorded in a particular document, if it is intended to be sham and it is not intended to be acted upon. And I believe that there is a recent division bench ruling of the Kerala High Court also, wherein this particular...
in the case of agreement to sell will be normally such contents will be taken that it was not never intended.
There is no passing of title, unlike in the case of a Binami. In Binami, there is a passing of title, but not to the ostensible purchaser.
Because in that be the case, see, normally all these questions would arise only when a party asserts that there is an entirely different transaction, and that what is recorded in this particular document, it is of no consequence. Right. So I think it is covered by this 36 Privy Council decision, which is brought by the Supreme Court.
Could be. Then I have one more doubt, which may be still foolish. Will it see a written will, whether registered or unregistered, can be cancelled by an oral will? Am I right?
I don't know, sir. I'm doubtful.
Will, of course, will. The last will survives, whether the earlier one is registered or not.
Question is written or not. Will cancelled by an oral will.
Oral will.
Oral.
If duly proved under Section 63 of the Succession Act, Proviso to Section 68 of the.
All these, I think that it will be arises only if it is a compulsory registrable documents.
It is not compulsorily.
No.
It is not registered. It is only written.
Writing.
My humble submission is this, sir. Oral wills cannot be executed by ordinary citizens. Oral will be executed by persons working in military because
privileged will.
So,
you mean privileged will?
Not arise in the case of a common citizen.
Privileged, sir, that has to be examined.
Yes, sir. Oral will by.
I wanted to know whether with regard to the applicability of Proviso 4 to Section 92, in the case of a will, the existence of any distinct subsequent oral agreement to rescind or modify any such contract, grant or disposition of property may be proved, except in cases in which such contract, grant or disposition of property required to be in writing or has been registered according to law.
Sir, there Section 100 may come into play.
Succession Act.
Section 100 says that
will not apply.
Saving of provisions of Indian Succession Act relating to wills. Nothing in this chapter contained shall be taken to effect any of the provisions of the Indian Succession Act 1865.
As to construction of
one thing I know, a registered will can be revoked by an unregistered will.
Yeah, that is good. The last will only survives. Registration does not give
ambulatory. Will a testamentary document being ambulatory in character, when a earlier will, registered will, is followed by a subsequent unregistered will, the earlier will goes.
Okay.
Shyam, again, just read Section 100 what you displayed right now.
Indian Succession Act.
Where exactly is that word contained? See that? It does not say as nothing contained in this chapter. Read it. Nothing in this chapter.
Prem, it is the Indian Succession Act, not Evidence Act.
Nothing in this chapter contained shall be taken to any provisions.
It is not as if nothing contained in this chapter shall be taken to effect. See the words. Nothing in this chapter contained shall be taken to effect.
Yeah.
Does that make any difference?
We can have another webinar on that.
Yes, yes. Anyway, wonderful presentation. In fact, even layman will understand these sections. Beautifully
Thank you
articulated.
Ramushan.
Really, it's I don't think that anybody can, in a simple language like this, can explain the Evidence Act. Because if you read the section, you have now introduced a method as to how the Evidence Act will be understood by reading the explanation first and then go to the section.
Illustration.
That is
illustration.
illustration.
Great people who wrote this wonderful enactment. Outstanding
Yes.
craftsmanship.
No, that's what the Sitaram sir also said. Nowadays,
And
there
the
is
systematic way.
no explanations at all. So in order to avoid any difficulty in understanding the provisions, explanation, the plausible explanations have been given, anticipating what are all the things may happen. But such an anticipation is not there nowadays when the legislations are being passed. So that is the reason why inconsistent interpretations are being given to the section. And we are getting number of conflicting or whatever be, and then again refer to larger benches also to the further larger benches. So many things happens.
What a systems approach in the drafting.
Yes.
No, there is no legislative drafting. The drafting, training is there for the present legislators.
Well conceived statute.
Running short of time, I'll just rush through the
Ramush may grumble.
Nice.
Ramush may grumble. Nice. Hunger.
Yeah, we can hear it after some time.
He can't hold it.
A perfect learning experience, sir.
Thank you, sir.
Very illuminative.
Thank you so much, Gaurav.
Thank you.
Thank you so much.
Badrinath.
Yeah. Being tribunalized for the last 4 years, now this forum has given me an excellent opportunity to get re-civilized through the lecture by Justice Somayajulu. A simple, excellent presentation, and complicated sections are explained so simply. Hats off to you. Benefit is mine. Thank you so much.
Vikas, can you just put a question first?
Hello.
Yeah, please.
Good morning, my lordship. In case of forensic expert report, evidence is tendered in family court. Is it necessary to bring his oral witness of that forensic expert?
We are not clear. Voice is not clear. Voice is breaking.
Hello. Now, is it clear?
Same audio problem.
Because if I repeat it, would it be okay? You wanted to know whether when a forensic evidence is reduced in a family court, should the expert be examined or not? Is it?
Yes, sir. Yes, sir.
The expert is just an opinion, sir. It has to be proved.
Yes.
Simple. It's just an opinion.
Thank you. Because Nawaz Jan, please.
Hi, sir. Good morning, sir. It was a wonderful presentation that nobody has any doubt in Chapter 6 of Indian Evidence Act now, from 91 to 100. In such a beautiful manner, in an effective manner, you have presented things. I have two doubts. One doubt is...
You are contradicting yourself. You just said
nobody has any doubt. Means I need only clarification on that. It's not it's a supplementary thing.
Okay.
Adding to what you have already said. No contradictions at all. Because the section that you have made in every word of this statute is wonderful. So my doubt is, in continuation of the doubt raised by His Lordship Justice Ram Kumar sir. In a case where a soldier is dying in a battlefield, he had already executed a will, a written will.
Privilege will. Yeah, that is privilege.
At one point of time, he conveys to his commanding officer that he wants to revoke the will. And with that word, he dies. He succumbed to the injuries he sustained in the battlefield. How far that revocation of will, orally made by him, will be effective. Is there any exception for the soldiers to revoke a written will by means of an oral will? That is number one. Number two is exception number 1 of section 91, where it is said, when a public officer is required by law to be appointed in writing, and when it is shown that any particular person has acted as such officer, the writing by which he is appointed need not be proved. Is it that the appointment order with which that public servant, that public officer was appointed, is the appointment order that is referred here? If that means that appointment order need not be produced before the court as evidence.
Where do you practice? Where do you practice? District court or high court?
I am yet to enroll.
No, you will be running a risk when you practice in the district court and ask your PDJ to produce his certificate of appointment. Don't make that mistake. See, there is a general presumption that official acts are done in a proper manner. So when a public officer who has to be appointed by a gazette publication, etc., takes charge of his office and continues to discharge his functions, the rule is you need not ask him to prove. Suppose you get the evidence, let us say there is an evidence recorded in a district court, you are trying to prove it. You need not show that officer is empowered to sign on that deposition.
Absolutely.
So unless the appointment itself is in question.
Even then, ultimately, if it turns out that his appointment was defective or for want of title, whatever he did will be saved by the de facto doctrine.
Will be saved.
De facto doctrine.
As far as the soldier has been given a special right to execute this or oral will.
Yes.
But yes, he can, if he can manage to prove it. I mean, he will need a very good counsel, of course, to prove a oral will executed in a battlefield.
His own superior, given to his own superior.
Evidence of a very high order.
It will be like nothing. It will be not less than like a hearsay evidence, because he makes a declaration just before his death, and now it is the commanding officer who conveys that soldier so and so has revoked his will already.
That will be more than sufficient.
You can do it.
Thank you. Dilip, sir, please.
Good afternoon, sir. My question is with regard to section 92 and 99. According to me, section 99 is more is the clarificatory nature of what is contained in 92. 92 prohibits evidence being tendered on the terms of a contract between the parties thereto or a representatives there. And 99 enables a third party to let in oral evidence. And even without 99, that was possible in 92. Because even without 99, third parties could have adduced evidence.
Yes, it is made clear, that's all.
Yeah, that's only clarification. That's all.
Thank you, Dilip. Okay, Vijay, please.
I think I'm muted. I got nothing to add. I was just a student today, listening everything and noting down all this idea.
Yeah, it's done.
Somi, can you, am I audible? Am I audible?
Yes.
Yes.
Oh, it was a mind-blowing performance, Somi, and all the learned judges who are here. Just one small incident I wanted to share with you. In Supreme Court, we were fortunate to see giants like Jethmalani sir and all arguing. On one particular day, some five years back, I and my colleague were just sitting in one court, and we saw him reading very anxiously some book. So we were slightly curious. We slowly went to him. We just say, "Hello, sir, how are you? What is that book you're reading?" He turned and showed us the Indian Evidence Act. So we said, "Sir, you are reading this book?" That every day I get a new meaning from this act. And Jethmalani was holding classes in NLS Bangalore on evidence. He was the professor there. So we were just wondering, this great man sees meanings in this English Act even now. So that is what Somi today and all the learned people, the different way of approaching the whole problem. The illustrations explain the main section. Amazing. And Shyam and the organizers is a great opportunity for everybody.
Thank you.
Keep doing a great job. Thank you and best wishes to all.
Thank you, sir. Thank you very much. I think
Mr. Shyam, on section 99, I would like to give some clarification, sir.
Sure.
99, a wonderful question is put by a predecessor speaker. Section 99, when we read, sir, it is not clear whether this section applies only as between third parties or it applies also between a party to the contract, grant, etc., and a third party.
Yes.
Therefore, the matter went up to Law Commission. The Law Commission of India has expressed its opinion that the section should apply to both the situations.
Yes.
I request the youngsters to read 69th report of the Law Commission with Justice Gajendra Karkar as chairman.
Oh, great, great judge.
So he clarified that it applies between third parties and parties to contract also.
Yes, yes.
Should apply. Okay, sir.
Thank you. So we'll come to Prem and let's find out. Prem.
Somayajulu sir, it was a fantastic class.
Thank
It
you.
was absolutely wonderful. And I just have one small doubt, whether for the purpose of the section 91 and 92, whether a unilateral sale deed could be construed as a contract within the meaning of section 91. Section 92.
Disposition of property. It applies to all documents, grant or other dispositions of property. Wherever property is disposed, transferred, or legislatum generis from grant or other disposition.
Yes, Justice Somayajulu ji, whether a sale deed is a unilateral document?
No, he said it. I did not go into that, sir. But if it is possible, yes, it's a disposition.
Because there is a consideration paid, there is a participation of the other, though it's not a signatory to the document.
Yes.
Correct.
Because sale deed can be unilateral. There is a decision by a division bench of Justice Ram Kumar during 2012. I think that Vasu versus Parukutti Amma.
My ignorance.
No, because this exactly was the question that fell for consideration. I don't remember the page number. Vasu versus Parukutti Amma. There is a decision by Justice Ram Kumar and Justice Harilal during 2012. And this exactly was the precise question that fell for consideration.
Because he is not a, the purchaser is not a signatory, was not. I think now there is a amendment, Kerala amendment.
Now
Purchaser also should sign. Purchaser also should sign. Did not.
At that point of time, it was not like that. But still, this question, as Justice Murthy has put it, that is the right mode. Because no sale can be unilateral. Why? Because there is always an element of consideration.
Yes.
Even though one party is signing, that does not make it unilateral.
And the sub-registrar is expected to ask him whether he got the consideration.
Exactly. That of course is by means of the rules and all. But still, no sale can be unilateral. That exactly is the precise point.
Absolutely.
So you wanted to demonstrate that I was wrong.
No, I think that decision it appears the 2012 1 KHC 285.
Is it that Vasu's case, Vasu versus
yes. Vasu Varghese versus Vasu something like Varghese Parikutti and other.
Okay.
And dealing with 91 and 92.
Even I don't remember.
Exactly.
No, I got the HCC in my mobile, so I am able to.
Justice sir,
today you are not hungry.
No, we are coming to the end. I unmuting.
No, 10 more minutes there.
Just yes, Narayan sir. Yeah, please, sir.
Narayan, oh, sorry, sir. Chodle submission.
I am happy to see you, Somayajulu.
Thank you so much, sir.
After a long time, after a long gap.
Last after I appeared before your lordship in that Hyderabad arbitration.
That arbitration Justice Maruti and Justice Ramaswamy.
Yes, sir.
And myself.
Yes, sir.
Some dispute with some Chinese firm and all that.
Yes, sir. Yes.
I remember it very well. Apart from it, you are not leaving that loyalty towards Visakhapatnam and what I see, these ships and all that, you are repeatedly referring to.
Aston.
That loyalty towards Visakhapatnam.
I love my hometown, sir.
I clearly see. Whatever it is, as far as the discussion is concerned, very well.
Thank you.
The provisions chosen these are all actually troublesome provisions.
Yes,
Quite often, we come across difficulties while deciding matters. There is no doubt about it.
yes.
But as far as this drafting of legislations, legislative skills, there was some discussion. I'm not saying anything as far as the standards are concerned. Both at the state government level and also at the central government level, the concerned people, quite often when they will be meeting me about these legislations, the drafting of legislations, this reading, the procedure which they follow, the other problems and all that. I'm really surprised to see. Let us take Indian Evidence Act. Certain of the provisions had been introduced subsequently by amendments. You compare the drafting skill,
yes,
the nature of language used, the way in which the words are put. I don't know. I'm not saying that the persons who are drafting the present legislations, they are in any way inferior or anything like that. But somehow or other, we feel that difference. I do not know. I have been putting this question to several of these juries, legal experts, academicians, who will be quite often meeting me. I am now 73 years. In my long journey, for more than 50 years being inundated in this field of law, I came across several people throughout the country. Apart from this country, several of the experts coming from different other countries as well, from several law schools from US in particular, while being at Delhi for the last 10 years. This somehow or other, many are unable to answer. If any one of you can give an answer, I will be very happy and I will invite.
Sir, Narayan sir, we will be having an exclusive session on legislative drafting and the violence being done to the language the current endorsement. That's an accusation that is being made, sir. Definitely we'll address that also. Thank you. And as we come to the end of the 144th session, sir, we would like to thank the speaker of the day, Somayajulu sir, and he has got to rush also. I mean, he's got an engagement after we have been so long. And all of you wonderful participants, Justice Murthy sir, Justice P.S. Narayan sir, Ramakrishnan sir, Badrinath sir, and our earlier Virubakshi Gowda sir, and every one of you, sir. Thank you very much. Till we meet next Friday.
Thank you, sir. And take your leave, sir. Thank you.